DeFi and the intersection of law and privacy is a conversation that is happening at the DeFi Education Fund and in discussions across our industry. And to get into it, we're going to turn to Marisa Coppel, my colleague at the Blockchain Association, our head of legal, Amanda Tuminelli, Chief Legal Officer for the DeFi Education Fund, Aaron Mackey from the Electronic Frontier Foundation, and Jeff Hetzel from Consovoy McCarthy. Guys, come on up.
This is on? Okay, great. First, just an applause for Dave. He's the best MC. I think other than government relations, MCing is his calling, so I always appreciate it every year. Good to see everybody. I'm Marisa, I'm BA's head of legal. I'm very excited to be joined by my panelists. I'll start just by having each of them introduce themselves and give a brief background on their role and their involvement in the privacy/crypto intersection.
Hi everyone, my name is Amanda Tuminelli and I'm the Chief Legal Officer at the DeFi Education Fund. We are a nonprofit, nonpartisan that advocates for sound DeFi policy. Recently, that has looked like filing amicus briefs, suing the government, and becoming very active in comment letters on proposed rulemakings and working with members of Congress to make sure that they understand what DeFi is and why it's important.
Hey, I'm Jeff Hetzel. I'm a lawyer at Consovoy McCarthy. We're a litigation boutique right here in Arlington. Most of my work is suing the federal government, and most of those lawsuits are on behalf of crypto. We represent Amanda and DEF in a lawsuit against the SEC. We represent Coin Center in several lawsuits, their Tornado Cash civil lawsuit, their challenge to the 6050I reporting requirement. So yeah, we're involved in a lot of these fights, and I'm excited and grateful to be here.
We like suing the government in this room.
Hi, everyone. I'm Aaron Mackey. I'm with the Electronic Frontier Foundation, and EFF is a nonprofit digital civil liberties organization based in San Francisco. And we got into this game back in the 90s when one of our clients wanted to make email communications more private with encryption, and the federal government said that that was a munitions and that he was subject to export controls. And so we were one of the first through that case to establish that code is speech protected by the First Amendment. And as we'll discuss, those issues continue to persist and will continue in the coming years.
Thank you. Aaron, I'd like to start with you and just talk a little bit about the Tornado Cash and Samurai Wallet sanctions. And I guess we can zoom out and talk about how OFAC, the process of OFAC sanctions, and why an overly broad sanction is so problematic.
Yeah, so we'll talk about the underlying decision by the Fifth Circuit recently, but I think just going back in time to when OFAC made its initial designation, what it did is it designated Tornado Cash as basically on the designated foreign terrorist list, and what that meant, we did not know. Right? And it was so vague that it wasn't clear whether that was Tornado Cash, the commercial entity, right? Whether it was Tornado Cash as it exists on Ethereum, right? Or whether it was Tornado Cash anywhere. And what happened as a result of that lack of precision by the government was that you saw massive concerns, right? GitHub took down its repository of the source code, and all of these questions, including if I'm an academic researcher, can I host the source code to actually just look at it, to do security research on it? And it was in that sort of vague, broad assertion of regulatory authority that we saw a lot of deeply concerning chilling effects on a technology that at its core, right, is about protecting individual privacy. And I think that's sort of one of the biggest concerns about whenever government sort of gets into the regulatory game, whether it's administratively or through civil enforcement or even criminal prosecution, is the lack of precision often leads to incredible spillover effects that are deeply concerning to anyone who wants to develop privacy-enhancing technologies.
And there's always this tension between privacy and government objectives with national security, right? So we definitely saw that with Tornado Cash. And I think the privacy risks on blockchain technology are just inherently greater. So Amanda, can you talk a little bit about why it's so important to maintain privacy using distributed ledger technology?
Sure. So I think, as a lot of people in this room can relate to, there are things you just want to buy and don't want people to know about them, right? We can have great reasons for wanting to have financial privacy. You could have no reason for wanting financial privacy. But I've recently, I heard somebody say this recently, like, if cash was to be invented today, the government would not allow us to invent cash, right? And I think that, like, what decentralized blockchain technology has done is allow people to transact online in a way that cash should let you transact, right, in private transactions. But as you know, if you are connected with your wallet address, your transaction history is no longer private. Everything you do on chain is easily connected to you. So software like Tornado Cash and other privacy-preserving software allows you to get back to that cash-like system while still transacting on chain. The problem is that the government wants to hang compliance obligations on someone. Its system is built for an intermediary-based system, and without intermediaries, it's difficult to figure out who should comply and with what. So that's the tension between us all wanting financial privacy on chain and the government trying to do their job of policing crime and bad actors.
And we're seeing this pop up not just with the Tornado Cash case and issue generally, but I mean, it's relevant to the broker rule that we're expecting to be finalized by the end of the year, which really hoping it's not, but it likely will be, where if a person's wallet address is made public, that just gives everybody in the world access to a ton of financial data and their history, which is a big problem. So, but going back to Tornado Cash, I want to talk about the recent win in the Fifth Circuit. Just add it to our list of wins. Jeff, can you talk a little bit about that case and your case as well in the 11th?
Yeah, so there are two civil challenges to OFAC's Tornado Cash sanction. We represent Coin Center in the 11th Circuit one. The 5th Circuit one was just decided in favor of the challengers a couple weeks ago. So the 5th Circuit held that OFAC's sanction of Tornado Cash exceeded its statutory authority and was therefore unlawful. So this is a statutory authority case. It's when the executive branch takes some action like it does here, it has to point to some pre-existing statute passed by Congress that authorized it to take that action. Here they pointed to IEPA, the International Emergency Economic Powers Act, which is basically for prohibiting foreign trade with foreign enemies or with other designated foreigners during a national emergency. As you can just kind of tell thinking about it, that's not really what they did here. What they did here was they banned Americans from using privacy-enhancing technology. So, like, you know, they made it a felony for any American to just put their own crypto into and take their own crypto out of the Tornado Cash immutable smart contracts. And so it was a misfit with the statute, and the Fifth Circuit said that. It said that this sanction falls outside of the statutory text of IEPA. It's therefore beyond OFAC's statutory authority. In general, it means that IEPA can't, or OFAC can't ban Americans from using immutable smart contracts just because they say were originally written by foreigners or could be used by foreigners, these kinds of attenuated links that OFAC tried to rely on here. I think the Fifth Circuit's opinion was really encouraging for us in a few ways. One, you know, these are generalist judges, and you never know how they'll engage with crypto, and there's a very careful, very detailed explanation of crypto and of privacy-enhancing technologies in Tornado Cash from the Fifth Circuit that, you know, is great for the public to read and shows a lot of respect and concern for the industry. And then the government tried to make this argument that, you know, we've all heard a million times, it's like, if you let this happen, then the terrorists will use it, the bad guys will use it, crypto's dangerous. And the court said, Our job is to apply the law. It's Congress's job if it wants to ban this, but our job is to read the pre-existing authorities and apply them, and we're going to do that faithfully here, and the Fifth Circuit did that.
And what's the status of your case in the 11th?
So our case was argued, and we're awaiting decision. So it could come down today. It could come down in many months.
Do you think that they'll look to the Fifth Circuit in making their decision?
So I'm limited in what I can say here because we're on the case, but courts are always interested in what other courts have to say. It's the same arguments, the same claim. Courts typically are interested in what other courts have to say about the same arguments and claim.
And I would just say they might want to avoid a circuit split if they don't want to get overturned. So.
Good point. I'm excited for that decision to come down. Okay, I want to switch gears a little bit, talk about the First Amendment, and I'll go to Aaron. How do you think that we or an individual whose First Amendment rights might have been violated by developing, how can we use the First Amendment to protect developers?
Yeah, I think the important thing to understand is this concept in the law is not new. So we're almost close to 30 years since the Bernstein decision, in which courts have recognized that code is expressive, and so therefore, just like any other means of expression, languages, et cetera, that is protected by the First Amendment. And built upon that is the recognition that the First Amendment is not sort of a binary on-off switch when you move from, say, just writing the code abstractly to actually implementing it and executing it, right? And so there's a lot of good case law in appellate courts, federal appellate courts across the country that recognize that the First Amendment applies. And so the question then becomes sort of what do you do, right, if you are, how can you maybe use the First Amendment to protect you, particularly if you're someone who wants to create these types of privacy-enhancing tools or even speech-enhancing tools, right? And so I think the main thing for folks to be aware of is that when the government is, whatever means it's using, whether it's a regulatory effort, whether it's civil enforcement or even a criminal prosecution, the First Amendment does apply, and then the question becomes sort of, what test does the government have to meet under the First Amendment to satisfy whatever its aims are? And oftentimes what we're looking at is, what is the government trying to protect? What is its interest, right? And it can't just be something that's like, oh, this would be nice. It usually has to be a compelling or a very strong interest. And how is that tailored, right, to the means by which it's doing that? And so, like, just to go back to look at Tornado Cash, right, what you see is a very broad effort that sort of had this really broad amorphous idea of what we're trying to protect, and it wasn't really tailored, right? Because at the end of the day, there was all these others who were caught in the net, including people who just wanted to host the code, who maybe wanted to look at it, identify security flaws, and maybe make it better. So I think that those are the types of considerations that people need to be thinking about. And I would really say the government is first and foremost the party that needs to be thinking about it, that as it steps into these various regulatory roles, it's not that the First Amendment is a brick wall, but it is something that they have to be aware of, particularly when people have a right to build these tools and to express it via these executable codes.
It's interesting, too, to think about how the First Amendment is used in litigation and what types of arguments are brought up. And if I'm recalling correctly, I think in your Tornado Cash case, you made an argument not that the developer has the right to code, but that a person using the Tornado Cash protocol is exercising their First Amendment right to freely associate.
That's exactly right. So one of our plaintiffs used Tornado Cash to make donations privately to Ukraine and helped other people do that. And he was only able to make those donations if he had privacy on chain. And so he stopped making them after the sanction came down. And so basically what they did here is they effectively banned him from making a transaction that's undisputably protected by the First Amendment, because the First Amendment protects your right to donate money and crypto to causes that are important to you.
Yeah, it's interesting to just think about, I feel like when we think about the First Amendment in this industry, we always think about the right to code, but there's other aspects of the First Amendment that we can use in these litigations in very creative ways. So I'll just open it up, but do you guys have any thoughts, Amanda, if you want to take this one, but if whoever can, on just how we might see the First Amendment come up in litigation going forward?
I'm struggling to answer this question in a public forum. We are thinking about whether there might be room to use the First Amendment as an organization, right? We also have a constitutional right to speak and to receive donations, and our donors have a right to donate to us under the First Amendment. And we are thinking about how it may make sense to assert those rights against the government.
Cliffhanger.
I will just add that I think we're going to get more law on this relatively quickly. Just noting, like in the Tornado Cash, the criminal indictments, one of the issues that has been briefed on a motion to dismiss is whether or not this activity, much of the allegations actually seek to prescribe First Amendment protected activity. So I think we're going to get more line drawing, and we should be aware of efforts or to the extent we don't like those lines that courts are drawing, to make sure that we're pushing back and sort of maximizing people's First Amendment rights.
Okay, I want to jump to Section 1960. Amanda, you recently published an amazing, very thoughtful paper on Section 1960 liability. So I'm hoping you can just give a brief overview of what Section 1960 is, because I'm sure there are people in the room that aren't familiar, and just a little discussion of what you talked about in the paper.
Sure, happy to. So Section 1960 refers to the criminal code provision that punishes people for running an unlicensed money transmitting business. So if you've heard the term money transmitting business, it's probably in the BSA, Bank Secrecy Act context, because there's also statutes related to the BSA that talk about what a money transmitting business is. But this is the criminal code provision that means criminal penalties for running an unlicensed money transmitting business. And I was proud to co-author a paper with Dan Barabender and Jake Chervinsky about Section 1960 and how the government, recently the DOJ, has been misinterpreting this statute. You've probably heard of it in the context of Tornado Cash, because one of the charges against Roman Storm is a Section 1960 conspiracy charge, and it's also at issue in Samurai. But there's also non-public DOJ investigations going on right now where some of the only focus, or the majority of the focus, is only on running an unlicensed money transmitting business. And what we learned when we went back through the statutory history is this provision was really meant to be an enforcement mechanism for the BSA. It was meant to be a licensing punishment, right? If you didn't get the license you were supposed to get under the BSA, there's a criminal penalty for that. But after the Patriot Act, they amended the statute and they added this provision, which is like what we refer to as like the or otherwise provision. It goes beyond just saying you didn't get the state license or the federal license. It criminalizes all this other conduct. It gets very broad, and that's the provision that the DOJ is using to go after software developers who are publishing non-custodial protocols that allow people to engage in peer-to-peer transactions. That is just not what Section 1960 was ever meant to cover. The definition in 1960 of money transmitting is transferring funds on behalf of the public. I am not transferring funds on behalf of anyone if I do not take custody of your funds, if I don't control your funds, and if it's a totally peer-to-peer, non-custodial software network. So our paper goes into the actual interpretation of the statute, how the DOJ is getting it wrong in these ongoing cases, and what we want to do is get the statute amended and make sure the DOJ stops using it the way that they've been using it.
And why would it be so bad if a software developer had to register as a money transmitter?
Well, I mean, like, register as what, and who's doing the registering, right? So, like, if you publish a non-custodial software network that allows peer-to-peer transactions, and then you suddenly have to comply with the BSA or state licensing regimes, you don't actually have the information that they want you to report, right? I don't have, if I'm that developer, I don't know who's using my protocol. I don't know what their transaction is for. I don't know who's on either side of the transaction. I literally couldn't fill out the forms that you would need to fill out to comply with the reporting obligations. But the DOJ is not seemingly concerned about that, and I think in the context of 1960, it's just, you know, the BSA is like bad and onerous enough, but in the context of 1960, we're talking about criminal punishment. You can go to jail for up to 5 years for violating 1960. So it's just the highest potential punishment or highest potential risk.
One of the kind of most scandalous things about the 1960 issue, which Amanda's paper is awesome on, is that for a while, you know, FinCEN said that this business model was not money transmitting. There's a civil enforcement mechanism. Civil penalties were not brought against these people. No one told anyone that they were changing their interpretation of it. And then the DOJ just comes with these criminal indictments that will put these people in prison for their new interpretation with no notice, which kind of raises much greater legal concerns when you do it criminally, just when you think about like basic due process and fair notice.
Yeah, I mean, it's like regulation by enforcement, but on another level because people go to jail. Could be for a very long time. Jeff, can you talk a little bit about both mics? Section 6050I and why that raises some important privacy concerns and your case and the status of it?
Yeah, so 6050I is a lot of these things that we're talking about are executive actions, and that made them easier to do, but also maybe easier to undo or to stop doing in the future. 6050I is legislation. It's passed by Congress, so it's a more entrenched problem. In the 2021 Infrastructure Act, this transaction reporting requirement was enacted. Basically what it does is it says that if you receive over $10,000 in crypto, you have to report that to the IRS. You have to report the amount of the transaction, the date of the transaction, the nature of the transaction, the social security numbers, name, and addresses of the sender and the receiver yourself. You have to do that within 15 days or you commit a federal felony. Unlike every other tax report in existence, the IRS can share these reports with federal, state, local, and foreign law enforcement. So without probable cause, without reasonable suspicion, they can give your whole transaction history to your local sheriff or to, you know, some foreign country's law enforcement. The statute says it's limited to $10,000, but you also have to report related transactions that add up to over $10,000. And because you don't know if you're, like, if I get crypto today, I don't know if that'll be related to a transaction later that might add up to over $10,000. So you basically have to do preemptive KYC just to ensure that you stay in compliance. The statute says that it's limited to receipts in the course of your trade or business, but the IRS interprets this very broadly. It applies to individuals, it applies to nonprofits receiving donations. So it is a massive reporting requirement that effectively makes it impossible to use crypto privately. It has been passed. The executive branch has stayed enforcement of it pending regulations, but that is just temporary. We represent Coin Center in their lawsuit challenging this. We think it's unconstitutional. You know, if the sheriff came to your door and said, give me all the records of all your crypto transactions ever, without probable cause, without reasonable suspicion, every judge in the country would say that's unconstitutional. Here, they can get those exact same things just by going through the IRS and getting your 6050I reports. It's also going to be impossible to comply with because, like, as we all know, like when you get crypto, you might not be able to verify the social security number of the sender. And if you don't do that within 15 days and send it to the IRS, it's a felony. So this is an ongoing problem. I think it's going to kind of get more attention going forward, and we're fighting to stop it.
And your case is on appeal?
So the district court, we sued. The district court said that we didn't have standing. The Sixth Circuit said we do have standing. So we won the appeal. We're now back in court fighting the merits.
Awesome. We only have a minute left. So I just want to look toward the future for a bit. And how do you think, and anybody can answer this, how do you think that these privacy issues will evolve through the next administration?
I think when it comes to the criminal prosecutions, I think the answer is we don't know. I think what's important for people to understand is that these criminal prosecutions are brought by federal prosecutors within the Department of Justice, but it's largely local, and there are decisions that are made at much lower levels than that would depend on, say, the appointment of an attorney general. And so I think we just don't know.
Yeah, I would say I'm cautiously optimistic. I would like to, there definitely are members of Congress who are educated about these issues, and we're going to make sure that they stay educated and we reach more people. But I think that with a new administration, there is time for change, and there are people who are interested in changing it. But I just, I'll believe it when I see it. So we're going to keep doing what we're doing, but we're hopeful.
I agree. It's hopefully it goes better. If they do something illegal, we'll sue them.
In the meantime, this is not legal advice, but just please don't do dumb shit. Thank you so much. This was a great conversation, and thanks all for watching.